Welcome, everyone. Thank you for joining us today for our second of our 5 webinars this week as part of our 32nd Annual Employment Law Update. My name is Hana Kern, and my presentation today is Workplace Accommodation and the Interactive Process Through the Lens of COVID. So today I'm going to review with you the requirements of workplace accommodation and what the interactive process looks like. I'm not looking only at COVID, but I will be talking about COVID and pandemic-related issues as they apply to this topic. So, as an initial point, this is a challenging area. I'm sure that is not news to many of you. The laws are complex, they're not particularly clear, and the decisions that you have to make in this area are very nuanced in that every situation is different. Every employee that comes to you seeking accommodation, it has their own set of circumstances that need to be considered. So even those of us who've been practicing for many years in this area still do find it challenging. So of course this year we have the added layer of COVID, and you're looking at accommodating employees not only through that process that has been in place historically, but also now you're considering, are these employees high risk, and how can I accommodate them in this COVID environment? All of this requires special consideration, and all of this you're dealing with while your businesses are being impacted in unprecedented ways. You know, thanks 2020. I saw a meme this morning that had a bunch of aliens and it said, looks like we're up next. And I hope the aliens aren't coming. So we'll cover what we can today. I'll answer your questions to the best of my ability. And then our panel session on Friday, where we'll take Q&As, will be an opportunity to get some more of your questions answered. So let's start off with what law applies to my business. So I'm just taking a bird's eye view here. We've got our federal law, the Americans with Disabilities Act. We are talking about Title I, which prohibits discrimination against qualified individuals in the employment context. Who does it apply to? Private employers, state and local governments, employment agencies and labor unions, and every employer of those if you have 15 or more employees. We also have our Washington law against discrimination, which applies to 8 or more employees. And now we also have high-risk worker protection under COVID with the governor's proclamation. And we'll talk about that as well. All right, what's the purpose of these laws? Well, pretty simple, right? We want to prohibit discrimination. We want to allow people with disabilities to have the same employment opportunities as everybody else. And when are you supposed to be thinking about these laws? Pretty much all the time. So they apply when you've got applicants coming in, as you are posting your job openings, hiring, firing, and really everything in between: advancement, compensation, training opportunities, and a catch-all, other terms, conditions, and privileges of employment. And I do want to mention one thing. In order to have you go through this process with someone with a disability, that individual still has to meet the underlying requirements for the job. They have to meet the qualifications. So if you've got a job opening and the person to fill that job has to have an accounting degree, you know, the applicants still need to have that accounting degree. In other words, they do have to meet the minimum threshold requirements for the job. So then we look at, well, is the employee an individual who is qualified for the protection of these laws? Under the ADA, we're talking about someone who has a physical or mental impairment that substantially limits a major life activity, or a history of a substantially limiting impairment. Our standard here in Washington is broader than that. It's more comprehensive. It says it's the presence of a sensory, physical, or mental impairment that is medically cognizable or diagnosable or exists as a record or history. Crystal clear, right? No vagueness there. So under the Washington law against discrimination, a disability can be permanent, but it can also be temporary. You have to accommodate temporary ones as well as permanent ones. It can be a common one. It can be something you've never heard of. Okay, it can be mitigated, right? The person can be managing it It can also be unmitigated. So the takeaway from this is it is broad. If you think it might be a disability, it probably is. So one of the questions that we always get is, well, can you ask? No, of course you can't ask. That would make life just a little too easy. You cannot ask someone if they are disabled. You can't ask them about the nature of their disability. You can't ask them about the severity of their disability. You can't ask disability-related medical questions. Can you ask anything at all? Why, yes, you can ask some things. You can ask if the person can perform the essential functions of the job. So that's really the focus in this process, is we're going to want to make sure you know what the essential functions of that person's job are, and your focus in your inquiry is, can they perform those essential functions either with or without accommodation? The duty, the initial duty is on the employee to make the employer aware that they have a condition which qualifies and which may require accommodation. There's recent case law, both on a federal level and here in our state of Washington, that confirms that. By the way, as an aside, I am not doing case sites in my slideshow today. I'm focusing on best practices for you folks and practical tips. But if there's anyone out there that would like the specific sites to the few cases that I'm talking about, I'm happy to provide those. And I encourage you to just shoot me an email and I can send those off. So the recent Washington case talking about the employee having the burden of giving the employer notice, and a very recent case out of the DC circuit, a federal case talking where the case was dismissed because the plaintiff never failed to request accommodation and there were no circumstances which would have indicated that the employer knew about it. Now, here's the kicker though. If the employee doesn't say anything and you do find out about their disability, maybe it's something that is apparent to you or you found out through some other means, you know, the obligation to accommodate is triggered. And that's tricky because there's a lot of questions you can't ask. So no one said that this was going to be easy. It is vague and it is specifically focused on whatever that individual's condition is. So let's touch on COVID just a little bit right now. What kind of COVID related questions can you ask folks? Here's one that I've been asked recently. You can't ask them if they have a family member who has COVID or who's been exposed, but you can ask them if they've been exposed or if they've been around anyone who's showing symptoms. You can certainly ask them if they are showing specific symptoms. You can't ask if they are immunocompromised. That comes into play with high-risk workers, so you can't ask that. You can't ask if they have a condition that makes them more susceptible to COVID. You can do things like requiring temperature checks. You can require self-reporting questionnaires, which we're seeing a lot of folks doing. In this area, the best practice is for you to be asking all of your employees the same questions. We don't want to see you singling out folks that for whatever reason you may believe are at a higher risk or that you believe may have been exposed. The best practice there is to have all of your employees that are coming into the workplace answering the same questions. If you're doing temperature checks, you're doing those across the board. All right, let's take a brief look at Governor Inslee's high-risk worker proclamation. It provides special protection to high-risk workers. There is the number of the proclamation if you'd like to look it up specifically. And this proclamation has been extended twice and guidance has been issued. So it's not comprehensive. There are still quite a number of unanswered questions about how this plays in with other obligations that employers have, but there has been some guidance. So high-risk workers are defined as people over 65 and also those with certain chronic underlying health conditions regardless of their age. It applies to all Washington employers. So let's look a little generally right now at the interactive process that you are required to engage in order to provide the appropriate workplace accommodation for an employee that requires accommodation. The Washington Law Against Discrimination and the federal ADA all require and contemplate a flexible interactive process. So what the law envisions is an exchange between the employer and the employee, where each party shares information and seeks information. Of course, there's certain things you can't ask, but generally that's the framework. All right. So generally, the kinds of things you're supposed to do is discuss the employee's request, discuss possible accommodations. You can request specific additional information about the accommodations that are requested. You can also propose different accommodations. It's certainly a fine line. You can't ask about their medical condition, but you could ask about the specific challenges that they are going to face in terms of performing those essential job functions that will help you explore what kind of accommodations you could provide. You can ask specifically what kinds of physical limitations might exist when they've raised one. For example, you have an employee whose job entails sitting at a desk all day and doing data entry. And they've come and said, well, I have back problems, I can't sit all day. So you can ask questions about the sitting aspect of the job, right? You might be able to say, could they sit on a different kind of chair? Could they do their job standing up? Is standing okay? Can they sit for certain periods and maybe take breaks? That is the specific accommodation they're requesting, to not be required to sit. You could also ask, consider whether there are other jobs they could do that don't require them to sit. A temporary leave of absence is an issue as well. So one thing I want to touch on here is that many employees do not understand the interactive process. They don't get that there's an interactive process, and a lot of them are under the impression that they can come to you perhaps with a doctor's note, and whatever that doctor's note says, you are required to do. And that is simply not the case. It is not a bad idea to let your employees know upfront when you're faced with an accommodation request how the process works. It is not a one-way street. The goal is to enable them to be a successful member of your team, and you need to work together to make that happen. One thing that our cases have made clear is the employee does have the duty to communicate. If the employee, there's an accommodation that's offered and the employee thinks it doesn't work, they don't say a word and they just quit, well, there's case law in our state saying that they didn't meet the requirements. So it's a good idea to let your folks know right up front what that process is going to look like, and that will make them more comfortable and hopefully will make the process go more smoothly for everybody. All right, let's look at what you don't have to do as an employer. As I already touched on, you do not have to provide whatever the employee wants, right? They don't get to march in and dictate the terms. You also don't have to do something that presents your business with an undue hardship. As with a lot of things in this area, what constitutes an undue hardship is vague. It's been defined as something that presents significant difficulty or expense. Please keep in mind that it's not just any expense. You may be required to spend some money to accommodate someone. So undue hardship is out there. It's, as I said, it's not wide open, it's a little vague, but that's one way to kind of limit the kinds of things you have to do. What else don't you have to do? Well, you don't have to fire someone else in order to accommodate one worker. You don't have to give them someone else's job if that person is going to be fired as a result. You don't have to make up a job, okay? And importantly, you don't have to excuse them from performing the essential functions of the job. And one important point too is you aren't required to accommodate every employee in your employ who happens to be disabled, only those that need accommodation in order to perform the essential functions of their job. Okay, so you may have folks who have a disability of some kind, but they're performing their job just fine. They may come and make some demands, but you need to do that if they need that accommodation in order to perform the essential functions of their job. Let's take a look at what you do have to do. As I've mentioned, you do have to engage interactively with the employee. You do have to consider various options which would allow them to perform those essential job functions. You might have to modify and you might have to excuse non-essential job functions. And of course, then hopefully you can offer an accommodation so that they can continue to perform those essential functions of their job. One of the things that you also have to do is you have to be timely. Okay, when you get these requests, please don't sit on them. One of the other things that we advise is if you've gotten a request, you've reached out to the employee maybe with some more questions and you don't hear back, we'd like to see you reach out again. We'd like to see you be proactive. So if that employee truly has kind of dropped off the face of the earth as far as communicating with you, it will be easy to show down the road if you have to, that you kept stepping forward and you are meeting your obligations. Let's look at some specific considerations as far as COVID is concerned. Let's see, there we go. All right, oh no, first of all, we're gonna look at job descriptions. So job descriptions, very important. It is not required that you have a job description, but we do consider that a best practice. I keep talking about essential job functions. Well, how do you know what the essential functions of a particular job are? Oftentimes, the best way to know what those are is with a description of the job. We also recommend that you do those in advance. If you've got someone who has a disability and has come to you with accommodation requests, and you are at that point figuring out what the essential functions of their job are, it could look as though you are tailoring those to maybe not have to accommodate them, right? So if you have the job description well in advance, then that argument goes out the window. So you want to focus on the result or outcome of the job. And what we'd like to see you do is spend a little time on job descriptions. Okay, don't just bang it out, but think about what value, excuse me, what value does that job bring to your company? Why do you have someone doing that job? Job descriptions shouldn't be task-oriented, but should be more of a bird's eye view of what the reasons are for that job. All right, so let's take a look at some COVID considerations. You've always been required to provide interim accommodation if that's needed, if someone has a temporary disability. You're also have always been required to try different accommodations if the first one you've offered hasn't worked. But this is particularly significant with COVID. You know, we are seeing a changing landscape. Hopefully COVID will be over at some time, hopefully sooner rather than later. And some of the accommodations that you're offering might not be long-term, which is fine. The other thing under COVID is undue hardship may look different. If your business is really struggling, you know, maybe a financial outlay that would have not constituted an undue hardship before could potentially form a hardship now. And finally, the high-risk workers, right? We have to accommodate high-risk workers under the governor's proclamation. So let's take a closer look at high-risk workers. There are three categories under the governor's most recent iteration of the proclamation. Just a small bit of history, this proclamation originally went into effect June 12th, or went into effect and it was through June 12th. It was extended through August 1st. On the 29th of July, the governor extended it so long as the state of emergency exists or unless otherwise amended or rescinded. So this is probably here to stay through the end of our COVID situation. So three categories. The first one is folks over 65. They do not need to have any kind of health condition, that's just purely an age-based category. Second category is folks who are at increased risk per CDC guidelines. Those guidelines are available on the CDC website at the moment. The increased risk category per CDC includes things like cancer, chronic kidney disease, certain immunocompromised states, obesity, some heart conditions, and there are others. There's a third category, might be at increased risk, also under CDC guidelines. This includes things such as asthma, high blood pressure, certain other immunocompromised states, certain neurological conditions, including dementia, liver disease. Pregnancy is in the might be at increased risk category, as is smoking. Okay, so those are two to keep an eye out, and there's others as well. And as I mentioned before, the high-risk worker proclamation and your obligations under it, they apply to all Washington employers. So it doesn't matter how many folks you're employing. So what do you have to do? Okay, as an employer, what are you supposed to be doing for these high-risk workers? So you have to provide all available options for alternative work assignments to protect them from exposure if requested. The if requested piece is an important piece, and we're going to talk a little bit more about that. Okay. If a reasonable accommodation is not possible, for example, if that is an employee that absolutely has to work in your physical plant and the job absolutely requires them to work in close proximity to others, and it is just not possible to provide that protective gear, you have to allow them to take leave, all the leave to which they are entitled, and you are also required to not oppose their unemployment benefits application. You have to continue to maintain health insurance benefits until the employee comes back, even after their leave has been exhausted. And that is a tricky one for a lot of folks because some of your insurance plans might not permit that. So you need to work with your insurance plan. And hopefully you can get that taken care of so that you can comply with the proclamation. So you cannot permanently replace an employee who exercises their rights under the proclamation. You can hire a temp worker to take their place, but you've got to hold their job. And you may not require a worker to work remotely because they fall into one of the categories. So this particular proclamation, it's very worker driven. It applies if the leave or if the accommodation is requested. So you can't go in, for example, and require all of your folks who are over 65 to work from home, okay? The ball is in their court. One of the other things that you can't do is you can't enforce provisions in an employment agreement or a collective bargaining agreement that contradict the terms of the proclamation. So another thing that we want you to do is review those and make sure that you are not enforcing terms in those agreements that might contradict with what you're required to do under the proclamation. Another question that we see a lot is, can you ask for medical verification? Okay, if you've got a high-risk worker, can you ask them for medical verification? And here are the answers: no for 65 plus. Of course, 65 plus is just age-based, so that wouldn't come into play. The answer is also no for folks who are at risk, but yes for the folks that fall into the might be at risk category. However, there's a however here, and that is that you are still able to require verification if another law permits it. One example might be our Washington Sick and Safe Leave or the FFCRA. So if another law permits you to require medical verification, then you can do that. All right, let's go through some takeaways here from today, and then I'm going to try and leave at least a couple minutes for questions. I see we're already at 25 past the hour. So I'm going to emphasize again, the proclamation, Governor Inslee's high-risk worker proclamation, specifically says that high-risk workers are entitled to accommodation if requested. So what you shouldn't be doing is proactively identifying folks and approaching them if you view them as high risk and asking them if they want to work at home, or worse yet, telling them they have to work at home. Okay. And again, you can't require those folks to work from home. They get the choice. So what happens when an employee does come to you and requests accommodation under the proclamation? So the proclamation says right out there that you are to consider all available alternative work arrangements which would protect them from COVID exposure. So I see that as engaging in a process that looks like, the interactive process that you engage in under the Washington Law Against Discrimination or the ADA. What are the alternatives? I mean, the obvious one that a lot of folks have taken advantage of is working from home. A lot of folks are finding that even people who perform jobs that you wouldn't think would be able to be performed from home actually can. So folks, let's get creative, right? Get creative on that. There are some studies that show that some workers are more productive at home, which is contrary to some common wisdom. Can they temporarily be assigned to a different location if you have multiple locations? How about different work hours, right? Is their job one that has to be done at the same time that everyone is at the office? Would it work for them for you to stagger? Would it work for you and would it work for them to stagger those shifts? A leave of absence, right? Can you provide that leave of absence? Can you provide protective gear? And of course, we're seeing a lot of workplaces doing this. Most workplaces should be providing some kind of protective gear. Think about whether you can do that. Think about, maybe you have some people that had private offices in your business that are working from home. Can you give someone who normally worked in a cubicle or surrounded by other folks, can you temporarily put them in a private office? Would that help? Can you reconfigure, modify the workplace? Can you do those plexiglass barriers? Would that work in your type of business? So the key is to think flexibly and think creatively. As I mentioned, if you do provide a leave of absence, you can hire someone to take their place, but only on a temporary basis. You've got to hold that job, and you've got to continue to provide them with insurance. One of the questions that we tend to get is, can you fire an at-risk worker? The answer is you can. If, for example, if no work exists, right? Maybe you are a restaurant and you are closing your doors. You don't have work for any of your employees, any of your servers. So yes, you can lay them off. You don't want to negatively impact their ability to obtain unemployment benefits. So you want to make sure that they are able to claim unemployment benefits. One other thing that we want you to be really careful about is make sure that you are not considering high-risk status if you are laying off only certain workers, right? You don't want to just lay off those high-risk folks. Even if you do have to reduce the number of folks in a particular position, you don't want to be laying off just the high-risk folks. You also want to be aware of disparate impact, the concept being that a particular facially neutral layoff policy might unfairly or disproportionately impact your at-risk population. One common example we see with this is, let's say you decide you're going to lay off the highest paid workers in a particular category. Well, those might also be your oldest workers, right? So you want to be careful there. Let's see, can you refuse to hire someone or allow them to come to work on the basis that they have COVID? Yes, yes you can. The ADA permits an employer to refuse to hire someone or have someone come in if they pose a direct threat. The EEOC has determined that having COVID is a direct threat. I mean, that seems like a little bit of a no-brainer, but it seems important to say. If someone has been exposed or they have the disease, you absolutely can not have them come into the workplace. Let's see what else. I'm just gonna, don't retaliate. I've covered that. And one important thing that I want to leave you with before I take a look at what questions we have today is document. I touched on that throughout the presentation, and for those of you that have been to our seminars in the past, I know you've heard us say this till we're blue in the face. Document, document, document. This is very important through the interactive process. And you want to, if push comes to shove down the road and you've got an employee claiming you didn't engage in good faith, you want to be able to show those emails. You want to be able to show notes of meetings and what was discussed. You want to be able to show that you were complying with your obligations. All right, folks, it looks like we are at the end of our time. I very much appreciate you joining us today. So thanks very much, folks.